Okay, we'll go ahead and get started. Good morning, everybody. My name is Marty Mascari. I am with the North Central Texas Area Agency on Aging, and today we're blessed to have a group here from Haiman+Hogue to talk about Medicaid Made Simple. And I'm going to introduce Sheila, who's their marketing director, first, and let Sheila talk about the CEUs, which are going to be provided by Haiman+Hogue this morning. And so if you can move to the second slide, and then Sheila, I'm going to let you talk about CEUs.
Thank you, and welcome everybody. I'm sorry about the audio problems in the beginning, but I'm thankful that they're okay now. Haiman+Hogue is happy to provide these CEUs, and we do them on a variety of subjects. But let me explain to you how, it's very simple, but let me explain to you how it has to work. You will receive, and the follow-up email, the attachments are going to be, yes, you will receive the slides, and that's great for you to have, but you will also get a sign-in sheet and an eval form. Both of those need to be signed and returned to me, please, and then I will send you your certificate immediately. This is good for 1 hour of CE credit for nurses, social workers, AL managers, and LPCs. And like I say, we're more than happy to do that, but I do have to have those forms returned to me because our guarantor requests that. Okay?
Perfect. Do you want to go ahead and introduce our speakers, Sheila?
Sure, I'll be happy to. We have two speakers today. They are our Medicaid team. Rhonda Downing is the paralegal who has 18 years experience working with Medicaid. So any questions that you have, my guess is she can answer them. Jeff Crouch is our attorney who works with the Medicaid, who's certified and works with the Medicaid. He has 25 years legal experience. So my guess is between the two of them, there won't be a question that they cannot answer. They're happy to present it to you. And remember, this is strictly educational. This is not a sales technique. This is not trying to get anyone to come to our office. This is strictly educational. We're here to empower you so that you can help others. And that's our goal. Without any further ado, Jeff and Rhonda.
Good morning, everybody. Thanks for being with us this morning, and thanks for your patience through these technical issues. It seems like no matter how many of these things you do, something always pops up. I play in a band and we have these problems. Sometimes we get everything loaded in and it sounds great, and then we start playing and it sounds terrible. So thanks for your patience on that. Let me start by echoing what Sheila says. One of our main core missions here at Haiman+Hogue is education. We are passionate about education. We are passionate about making sure that people have the information that they need to be able to make good decisions for themselves and their family. And that's what we're really here about today, is to educate you so that you then can work with the folks that you're working with, deal with your family members, whatever the situation may be, arm you with knowledge that you can use as you go through your daily life, personally or professionally, so that you can have at least a starting point of knowing what you know and knowing, perhaps more importantly, what you don't know, and know where to point people for help. So let me start by dispelling a few myths and misconceptions that we'll be talking about at length here this morning. But just by way of summary, these are things that a lot of times we see our clients, potential clients, concerned about, talking about, worried about. So let's shoot a couple of those out of the water so far this morning. The first is that if I apply for Medicaid, Texas will take away my home. The home is an exempt asset. The home can be protected from Medicaid estate recovery. We'll talk about those things in detail. Texas is not going to take away your house, especially if you do proper planning. Another common misconception is that I have to be broke before I can get Medicaid. And although there is some financial limitations to eligibility, it's certainly not the case that you have to spend all your assets down to zero and then apply for Medicaid, and we'll talk more about that as well. Same thing with income. I make too much money to qualify for Medicaid. That's even easier to deal with than having assets. There are very specific and Medicaid compliant ways to deal with incomes that may be above the Medicaid cap. We'll talk about that. And I have too many assets, so I'll never qualify. Kind of goes along with I have to be broke. You don't have too many assets. It really doesn't matter up to a certain degree how many assets you have. We can fix it in a Medicaid compliant way to get you eligible, get your clients eligible. Another common misconception is that if I give away my assets, I have to wait 5 years to get on Medicaid. Not true. All of these things, or a lot of these things, have a grain of truth to them. The grain of truth here is that there is a 5-year look back period with Medicaid. But as you'll see, as we go through the slides and the conversation this morning, there are certainly ways to get folks eligible, even when you have to do pre-eligibility planning and not have to wait 5 years. Commonly, folks think, hey, I have health insurance. Why do I need Medicaid? Well, Medicaid is a long-term care payor. Health insurance helps, Medicare helps, but Medicaid, if you're in a situation where you're looking for a long-term solution to how to pay for long-term care, Medicaid is what you need to be looking at. Long-term care insurance is great if you have it or if your clients have it. It's very helpful and it can work in conjunction with Medicaid, but it is not true that if you have that insurance, you don't need Medicaid, because it may be that policy, that insurance coverage doesn't cover everything. And in those situations really acts more of a supplement. I mentioned Medicare. Another common misconception is that Medicare pays for rehab, so I don't need Medicaid. That is, again, there's a grain of truth to that. There is an element of Medicare that pays for long-term rehab, but when you get to the certain timing threshold, and it can be anywhere from 21 to 100 days, Medicare is likely going to drop out, and that's when you need Medicaid to step in. Another myth is that you have to stay in a nursing home to keep Medicaid, as Rhonda and I will help you understand, hopefully. There is a process by which, if you get qualified for Medicaid while you're in the nursing home and then get better and discharge into the community, then you can keep that Medicaid, because that Medicaid goes with you. There's a Medicaid follows the person process within the Medicaid program. Hopefully that allays some initial concerns. And here's the good news. It is possible to get Medicaid benefits without going broke, without losing your house, without waiting 5 years, because with the proper tools in place through the planning that we'll talk about, you can preserve those assets so that they are there for your clients, for you, if you need them for your care down the road. And so what we hope you'll take away from this, in part, is that don't ever assume that your assets are too high and that your income is too high, because we can fix that. If your income is above the limit, there's a specific remedy called a qualified income trust we'll talk about in more detail that can fix that. And remember, again, that health insurance and Medicaid, although important, they only temporarily cover these kinds of expenses. Likewise with long-term care insurance, it helps, but it has limits, and it often doesn't fully cover the cost. I have seen clients that have had legacy policies they've had for a long time that have completely covered the cost, but those are very rare and these days almost non-existent. If you can find good long-term care insurance, it also ends up being very expensive. But it does help if you're in a situation where you can still get it reasonably priced. Definitely want to take a look at that. In terms of the types of Medicaid that we're looking at, there are various different programs available. There are nursing home Medicaid programs. There's community-based Medicaid that applies when you get into an assisted living or group home environment, or even when you want to have care that you can keep when you go home. In-home care is part of the community-based Medicaid program. And there are also what we call Medicare savings programs. These are not as commonly used and not as well understood as some of the other programs, but they are out there. They can allow you to provide assistance with your Medicare costs. You see they're listed there: the Qualified Medicare Beneficiary Program, the Specified Low Income Program, the Qualified Income Program, and then the Qualifying Disabled Workers Program. We're really not going to talk a whole lot about those because they are of limited overall application, and they're pretty specific in terms of the threshold requirements that are different than most often used type of Medicaid. So we wanted to talk about them, make you aware of them, but we really don't intend, unless you've got specific questions, to spend a whole lot of time on those. So with that, I want to turn it over to my esteemed colleague and paralegal, Rhonda. Rhonda and I have been working together for several years. She came to us from another place, and we couldn't be happier to have her. She's a wonderful resource and a good person too, and that's probably the best part. So Rhonda, take it away.
Thank you. I want to start out a little bit this morning with just some basics of Medicaid eligibility. There are a handful of things that aren't really related to finances, and that would be citizenship. We need to have a disability or a medical need for the types of programs for which we're applying. And that just comes from medical evaluation of the person applying. The rest of it, when we get into the finances and what we think of as the typical eligibility criteria, Medicaid for the most part boils everything down to two columns, income and assets. And you can use the term resources in place of assets for our purposes. When you think about income, think about checks that come in monthly, such as Social Security or a pension. It is also important to realize that things like food or shelter that someone is providing to a potential Medicaid applicant could also count as income. So in reviewing this type of criteria, anytime you're receiving goods or services from an outside source, it's important to kind of slow down and consider whether these things are countable income in the eyes of Medicaid. When we consider resources, think about assets like cash value, perhaps money in the bank. Sometimes people have annuities or life insurance that have surrender cash values. And those are the things that are going to count in terms of the value of that particular asset for the resource or asset test in Medicaid. So anything you could, that you have that could be sold or surrendered for cash, consider the fair market value, and that's typically what we're going to count in terms of assets. When you're looking at assets, there are two types. Some are considered exempt or excluded assets. So I believe Jeff mentioned the house is a good example of that, and it does have a value limitation. So we can't have a $2 million house and expect that it's going to be excluded. However, other assets are going to be countable. So again, cash in the bank, think about the fair market value. And some of the excluded resources, let's kind of run through those. The homestead, of course, up to a certain value. A person could have one car. If they have multiple cars, one of those is going to be excluded and the others will count. When a person has prepaid funeral or cremation policies, those are excluded assets as long as they're irrevocable. So oftentimes people will assume they're irrevocable, but generally they're not. It's real easy to make them irrevocable. There's a form called a waiver of right to cancel that the party can sign, and the funeral home, for example, could sign, and that takes care of that. So again, as long as it's irrevocable, Medicaid won't count its value against the applicant. You can also have burial plots. So family burial plots are going to be excluded. If you have an excessive amount of those used for investment purposes, that would be a different story. But again, the ones that you buy for your personal use and the use of your family, those would be excluded. The next slide here is a list of some basic eligibility facts. So let's go through those one at a time. If you look at the top, the income cap, Medicaid will use gross numbers. So if a person's income is less than $23.82 per month, then they would be eligible in terms of income. Your next question might be, what if my income is higher than that? And that can be fixed. So even if you had, say, $3,000 worth of income, at first glance, it of course is above the limit. But the thing that Jeff mentioned earlier about correcting that problem is called a qualified income trust. You might see that abbreviated as QIT, and typically the nickname for that is a Miller Trust. The way that works, it functions very much like a clearing account. So there is a trust that's created. That trust will own a checking account. And say if I have $2,500 Social Security, I receive that, putting in the trust, and each month I'm paying it out for my care, and that solves the problem. The next number you see there is a monthly personal needs allowance. Think about that as a person's pocket money. And the way that it works is if I'm in a nursing home, for example, and I'm on Medicaid, say if my income is $1,500 a month Social Security, The way that Medicaid calculates what I'm supposed to pay the nursing home is out of my income, I get to keep $60 cash or pocket money for my own personal use. They would allow me to pay any of my health insurance premiums, and then whatever is left over will go to the nursing home, for example, as my copay. Meanwhile, Texas or Medicaid is covering the rest of my care costs. The next number you see there is individual resource allowance, and this again is where assets come into play. So at the time that I apply for Medicaid, my assets should be below $2,000. If I had $2,010 at the beginning of the month, then that would mean I'm over-resourced and I'm not going to be eligible. So when we do planning to get someone eligible for Medicaid, by the time that we apply, we will see that their assets are below that limit. The next number there is a couple resource allowance. And this is only applicable if you have a married couple and both spouses are going into the facility. We're going to get their combined assets below that amount in order for them to be eligible for services. The next number is monthly maintenance needs allowance. That's a bit of a mouthful. This is related to married people. Say if you have a married couple and maybe the husband is going into the nursing home and the wife is staying at home. If you caught what I said earlier about the copay, if that husband is going to apply for Medicaid, your first assumption is that all of his income is going to go to the facility. What's nice about this minimum, monthly maintenance needs allowance value is that, say if the wife is at home and her Social Security happens to be lower, maybe it's just $1,000. And if the husband is going into a nursing home and his income is $2,000, the thought of that wife losing the income can be really scary for her. So this threshold here, this maintenance needs allowance, is really designed to keep that spouse at home from becoming impoverished. So because in this example, her income was $1,000, his was $2,000. When I add those together, they're below this threshold of $32,590.50 in a month. And so Medicaid is going to say that this particular wife can keep her husband's income at home, again, so she's not impoverished, and then his copay to the nursing home might be $0. So you can use some examples with this rule. Say if her income is $2,000 and his is $2,000, what's going to happen is she'll be eligible to keep some of his roughly up to that threshold. The next two numbers are kind of a range, and those are the minimum and maximum community spouse resource allowance. The way that this rule works is, again, it's related to married folks, and if one spouse is going into the nursing home, this rule is trying to figure out what the spouse at home is allowed to keep in terms of assets. So say, for example, this married couple had a combined $200,000 in countable assets when the husband went into the nursing home. Medicaid will take that $200,000, divide it by 2, which equals $100,000. And because $100,000 fits within that range of roughly $26,000 to $130,000, that's the number that Medicaid is saying the spouse at home can keep. So anytime when you're running into situations where the combined assets are more, say for example, it's $500,000, 500 divided by 2 is 250. 250 is more than that maximum. So in a situation like that, generally we're going to want to reduce the assets for the spouse at home as well. The last number there, divestment penalty divisor. This is the way that Medicaid will calculate a penalty. So earlier Jeff said there is a 5-year look back period. So the way that this rule works is if within that 5-year look back, I have given money away, maybe to my sister, say if I gave her $24,000 roughly, then Medicaid would say, okay, you gave away $24,000. We're going to divide that by this penalty divisor. So you see the daily figure or a monthly figure. So roughly if I gave away the 24 grand, Medicaid might say you're penalized for 4 months based on the dollar value of that gift. So the more money I give away, the longer the length of my penalty period would be when I apply for Medicaid. All right, you've heard me say planning. When it comes to Medicaid planning, there are 2 approaches to it, pre-planning and crisis planning. If I'm pretty healthy, maybe I'm younger, healthy, have no imminent health concerns or suspicion that I might soon be in a nursing home, I might be in pre-planning mode. So say, for example, if I had maybe a family farm I inherited that I never want to have to sell, sometimes families will worry about that kind of thing. You know, what is going to happen if I have to go in a nursing home? Am I going to lose that family farm that I want to pass down to the next generation? So people like that might be a good candidate for pre-planning, because they might ahead of time transfer something like that into an irrevocable trust, or maybe pass it down to that directly to that next generation. And what you're doing is you're starting that 5-year clock ticking. So basically, if I made a transfer like that and I'm healthy a whole 5 years and Medicaid doesn't come along and change that look back period time, then I've given that asset away. And then later when I apply for Medicaid, as long as that look back period has passed, I'm not going to be penalized for having made such a transfer. So pre-planning is really done ahead of the game, perhaps for assets like that, or when we have a lot of time where we're still going to be healthy. Crisis planning is the really common thing that we run into, and you may also in your career fields. Crisis planning, perhaps someone has already received a diagnosis of Alzheimer's, dementia, maybe we're having some health issues, maybe high risk for stroke and things like that. So the typical story with a crisis plan, and to get through these slides, what I'm going to do is use crisis planning and nursing home examples in order to get the concepts across. And then when we get to the end of that, I'll relate that back to the community programs for Medicaid. So let's start by looking at an example, a crisis example. Typically the story that you hear is someone has some type of health event, or perhaps they go into the hospital for a few days. After that treatment is done, they send them to a rehab for skilled care. And maybe the person's health is not improving to where they could go back home safely. So say, for example, they're going to have to stay in long-term care. It's not really safe to go back home. The way that Medicare is going to play into this scenario is when we have a hospital stay of 3 or more nights, that triggers Medicare to temporarily cover the cost of rehab. So if, again, 3 nights in the hospital, we'll turn that spigot on for us. Day 1 through 20 are fully covered by Medicare. Day 21 through up to 100, and the term up to is really important. It's really conditional based on my progress. So if I'm not improving or I'm not participating in therapy, Medicare is going to stop covering the cost of it. Another thing that plays into this day 21 through up to 100 is the copay. So it's not covering the full ride. There is a copay, and that'll change from year to year. And in a lot of cases, that copay amount is roughly the cost of private pay at a lot of facilities, depending on where you are. Sometimes when people have supplemental policies, that might kick in to cover more of that rehab or fill in the kind of cracks or crevices that Medicare might leave behind. So say I've exhausted Medicare, and again, my doctors are saying maybe this person needs to stay in long-term care and they can't go back home. Medicare will stop paying, and what's going to happen is that family or that person is either going to private pay, or they might seek to get Medicaid to cover these long-term care costs. So let's start by looking at a single person. This is Mary. She's going to, roughly meet the example I just gave. She's in her 80s, has Alzheimer's. She had a fall, goes to the hospital for a week. So again, she's triggered that Medicare to cover some of that time for her. They send her to rehab, and she's not getting well enough. She's not going to be able to go back home. So she's going to have to stay in the nursing home. An overview of her assets here. Income $1,600. She's got a house, checking, savings, CD, life insurance, and that life insurance has a cash value. That's a countable asset. And she has a car. So think back to kind of the rules we went over, the things we mentioned. What's excluded in this example? The value of her house is low enough, so that's not going to count against her. Her car is also excluded. That won't count against her. But the rest of those assets are countable. And so right now, obviously, they're above $2,000. So we think, hey, she's not going to be eligible. That in all actuality, she can be. And in this example, note her income is below the income threshold, so she does not need qualified income trust. So what happens with Mary in crisis planning is, her house and car are already excluded, so they can be preserved. Let's stop for a second and talk about her house. A house is excluded, meaning its value does not count against me when I apply for Medicaid for her. But if she passes away and that house is still in her estate, Texas, having spent money for her care through the Medicaid program, can come back to her estate and seek reimbursement. There are ways to truly preserve the homestead. And in this, I guess in this field, sometimes you hear things about such a ladybird deed, transfer on death deed. Those are two different deeds that sound very, very similar. And in some circumstances, you might choose one or the other. So it's different for everyone. But the point is, the way that those deeds might work is that Mary can sign such a deed, the house remains hers throughout her lifetime. So she can live in it, sell it, revoke the deed, do whatever she wants. But at the moment of her passing, if she's not changed it, then that deed will say, okay, when I pass away, give this house to someone else. And that act actually keeps the house out of the estate, which means it won't be subject to recovery by Medicaid. There are different things that play into which deed is better for a particular person. So it's real important not to assume one way or the other, but to seek help for those kind of decisions. Another thing that we did for Mary here is purchase a prepaid funeral, because if you'll note, she didn't have one initially. It wasn't in her list of assets. But when we purchase one and it's irrevocable, that kind of takes that money out of the equation. It's something that people are going to need, so it typically is a good tool to use for some planning, whether it's pre-planning or crisis. The other thing that will happen for her is she's able to preserve about 65% of her remaining countable assets. And right about now, you're probably wondering, how did that happen? So I'll come back to that. The immediate application for Medicaid results in her getting eligible for Medicaid immediately. She might have a penalty period based on any planning that we did, but she's on Medicaid, eligible for Medicaid services, and they're going to be able to take care of her for the rest of her life as long as she's otherwise eligible for Medicaid. Let's look at another example. Again, a single person. It's John, 76, had a stroke, qualifying hospital stay, goes to rehab, and then can't go home. So this is a really common example or story that you'll hear in elder law. John's income and assets, you'll notice his income is above the threshold. He also has a house, and that house is excluded based on the value here. Checking, savings, CDs, here he has a prepaid funeral. Our next question is it irrevocable or not? And he has a car, which is excluded. So what can happen for John is the homestead and car, again, are excluded. He can do one of the deeds to make sure that that house is protected from recovery by Medicaid even after he passes. His funeral is easy to make irrevocable, so that's going to be excluded. And here he's able to save 75% of his assets. So if you compare these two examples, you might be wondering, why is that percentage of savings different for them? And a good way to look at it is a person's income in comparison to the cost of care. And around here, nursing homes might be an average of $5,000 to $8,000, again, depending on where you are. And the main point in this example is that John's income was higher than Mary's, so he was able to preserve more of his assets. And kind of the way that works is if you consider the cost of the nursing home compared to a person's income. The lower the income, the larger gap there is between having the money to cover the cost or not. So when a person's income is getting higher, that gap is closing. So the higher a person's income is, or if a person has long-term care insurance, it's kind of like having extra income. And the end result in planning for a person like that is the more income there is in comparison to the cost of care, the more of that person's assets they're able to preserve. Now let's turn and kind of look at a married example. And again, think back to these rules we went through earlier. You've got a married couple, Sally 68, Bob 74, and I always pick on the husband, bless his heart, and make him go to the nursing home. So I apologize for that for you guys out there. But anyway, Bob had a fall, was hospitalized for 4 days, goes to rehab, and again, can't go home safely. So he's going to stay in the nursing home. His income is high, $3,200 a month. That is above the income threshold for Medicaid. And Sally's income is fairly low. So this, again, fits that example I gave earlier when I was discussing the minimum monthly maintenance needs allowance for spouses at home. They've got a $200,000 house. That's going to be excluded. And again, checking, savings, some CDs, 2 cars. So one of those cars is going to be excluded. Doesn't count against us for Medicaid. And what's nice of them is they let us exclude the car with a higher value. So in this example, the $10,000 car won't count. The $6,000 car would count as an asset. So the end result in crisis planning for the married couple is the house and cars are saved. All of the assets are saved. And that's, you're probably thinking right now, wow, that's impressive. When you have married couples, there are plenty of rules that really makes it advantageous for them in terms of planning, because they're able to end up saving all of those assets for that spouse at home. So they have plenty to live off of. They don't have to go broke. They don't have to sell their house. And one of them can get on Medicaid. So let's talk about long-term care insurance, because I brought it up a couple of times. When you have long-term care insurance, a lot of times one of those myths that Jeff mentioned was, hey, I don't need Medicaid because I've got this policy. What's really important to realize is a lot of policies are going to have limits. They may have daily maximums or a maximum overall payout or a maximum overall period of coverage. So the common thing you might hear if you were looking at a variety of these policies is perhaps they cover $150 a day for 3 years and then it stops. Some policies, if they're really, really old, might pay indefinitely. So the longer ago it was that it was purchased, the likelihood is higher that it covers a little longer period of time. The benefits to it, you're going to have more care options potentially. It might help people stay home longer. It also helps extend the life of a person's savings or their resources. So even though someone has it, it's important to kind of look at it and see how are we best going to use it for that person. And again, that could be by staying home longer. It can also help them when you consider my example I just gave, when a person has higher income or long-term care insurance. It typically will allow them to do Medicaid planning and end up saving more than they would have without it. But again, just realize it doesn't cover everything indefinitely. Some of the planning tools that some of which we've mentioned, and some of these may be new. When we talk about Medicaid planning, there are several tools we commonly use, and it's kind of case specific in terms of what's best for a particular person. So one of the ones we mentioned was a qualified income trust. That again was the QIT, or the Miller Trust that we mentioned. And when that's used, it's an income vehicle. The word trust often gets people thinking, hey, that's where we're going to put assets, and that's not the case. So in the married example I gave, the husband's income was higher. I think it was $3,200. So in a case like that, we might have to filter his income through a qualified income trust, and that's going to take care of that problem. Annuities, this is a big one. Annuities are insurance-based products. They are contracts, and one can be very different than others. There's a lot out there on the market. In terms of Medicaid planning, what's really important is annuities do have some restrictions. So some of them are Medicaid compliant and some of them are not. If you run into cases where it's for you, your family, or clients where someone is selling them an annuity, just be careful about that in terms of Medicaid. They do have their uses, and a good example of that is, let's look at a single case. Say if the single Medicaid applicant has $100,000, and based on the facts of that case, we may determine that they can save around 2/3 of their assets. Whenever we're talking about preserving assets, often that means that some assets are going to be transferred out of their name, perhaps to a trust or to relatives, to kind of hold on to supplement their care. But in any case, when a transfer is made, it may create a penalty. And so the use of Medicaid compliant annuities in this type of example is really designed to take part of the assets, maybe convert them to income that might cover a penalty period. So if you run into a case where somebody's suggesting that you put all of a person's assets into annuity, that's a time to be a little bit cautious, because they do have rules associated with them where Texas might be able to grab some of the leftovers. So you want to be really careful about the subject of annuities. Again, deeds we talked about earlier, a couple of different kinds, and they're used in different situations. It's really important to realize that if someone just signs a deed, say if I just give my house to Jeff because he's so great, If I just gave it to him outright with the typical deed, that's going to create a penalty. So the ones that we mentioned earlier were death deeds, transfer on death or ladybird deeds. Those are different because I would keep the house during my lifetime. It doesn't pass anywhere until I've passed away. And because I did it that way, it accomplishes two goals. It doesn't create any kind of penalty, and it keeps the house out of my estate, out of probate, and it keeps it safe from Texas or Medicaid being able to recover against it after my death. The term spin down is frequently used in this area of law. Spin down, I personally, I don't like it a lot because it kind of implies that we're kind of spending or wasting assets just to get them below that $2,000. But what's important to note is a spin down could include purchasing assets that are excluded, such as prepaid funerals. Maybe if I don't have a car and it's useful to buy one, again, we could take some cash and purchase a vehicle that can be used for the person we're caring for here. So it's still a good term, even though I'm not a fan of it. But so purchasing excluded assets could be a home, could be a car, prepaid funerals, burial plots for me or for my family, for example. Pitfalls. In the Medicaid world, there's a lot of stuff on the internet. You hear people talking a lot, and that's where these myths and errors kind of come from. Estate planning is documents. So think about it if you've heard of wills, trusts, powers of attorney. Those documents are really important in terms of equipping maybe my spouse or my family with the tools they're going to need to take care of me if I'm the one that's going through this. So when people don't have documents and then they lose the ability to sign, perhaps because of dementia or Alzheimer's, it kind of ties the hands of the family a little bit and may land everyone in the courthouse to go through a guardianship to be able to take care of the sick person. So again, whether it's improper estate planning or a lack completely of estate planning, those kind of problems can arise. Sometimes I have documents. Maybe I get them on the internet and I think, hey, this is great. I didn't have to spend money on that. But what's important is documents are state specific and they're not all the same. So often the things that people are getting on the internet, they may be inappropriate for Texas and they may not have the powers we're going to want them to have for that person to be able to do some Medicaid planning. Gifting without proper advice is pretty dangerous. Often, as we age, a lot of times we say we want to give things to our kids or grandkids so we can see them enjoy it. And that's a noble cause. The downside is people don't realize when they start giving things away, it may create penalties for them. And often when they give too much away, they don't have enough left over to properly care for themselves or to cover any kind of penalty period they could have created by doing gifting. And that's aside from tax concerns. So it's really important, especially whether it's you, people you're working with, if they start talking about giving things away, you're in a great position to tell them, hey, maybe research that a little bit or get some help before making those kind of decisions. The do-it-yourself approach, a lot of times you just heard me mention the things that people get off the internet. They assume a lot of things, or they operate based on word of mouth or some false assumptions. And so anytime you're trying to do things yourself, sometimes you have the potential to kind of shoot yourself in the foot, whether you realize it or not. Deeds, the same kind of issues. There are a couple of different deeds I've mentioned several times that are good for people, that help them, save or preserve their house, keep it out of probate, keep it safe for their family. But if they do the wrong kind, it could trigger some unintended circumstance, whether it's penalties or it could upset the mortgage company and things like that. And playing by old rules. Old rules, Medicaid does change from time to time. So it's always important to kind of look into what the current rules and regulations are so you don't do something based on bad information. Speaking of rules, the treatment of IRAs is changing. A long time ago, in terms of resources, the value of a 401k or IRA would count against a person. So in planning, the thought of cashing it in, liquidating it, or moving it in some kind of way could trigger a lot of tax expense. What's nice about the new rule, and it's not in hard writing just yet, but but it is being implemented. It's always subject to change when they do put it in writing. So again, it's important to look into the current rules before making choices. But sometimes with IRAs, kind of what they're doing now is the value of the IRA, if it's an RMD status, RMD is required minimum distributions. So the old rule was when you get to be 70 and a half, and now they changed it to 72 and a half. If I have an IRA, I have to start taking minimums out. The way that the minimum is calculated is based on my age and life expectancy. So the older I am, the larger portion I have to take out. Anyway, those distributions are income to me. So Medicaid is starting to count the monthly amount as part of my copayment if I'm in the nursing home. But what's really nice is the cash value of that IRA now doesn't count against me if it's an RMD status. So it's really important when someone has an IRA, again, whether it's you, a loved one, or just a family you're working with in your line of work, that's a really important issue to kind of figure out, hey, is it going to count against me? If it does, how can I fix it? So some of the tools that can be used with IRAs is moving them into certain types of annuities that either maintain that excluded value. In the case of someone below that RMD age, again, that's a way to fix it. And another thing that you can do with them is when you have married couples, if you don't want income from an IRA to count against the person in the nursing home, sometimes it's possible to get it directed to their spouse at home, which is a really fantastic tool. So all this stuff I've been talking about, I keep talking about nursing homes.
Hey,
so,
Rhonda, before you move on, sorry to interrupt you. We did have a question on this, and so we can make sure that that's answered in the Q&A, but I did want to make the point in response to the question. There is a little bit less certainty with regard to 401ks. So the IRA policy, even though it's unwritten, is still pretty clear in terms of how HHS is applying that in practice. But it's a little more murky when we talk about 401ks and 403bs. So traditional 401ks and Roth IRAs, those things are not as well defined. So we have to be a little bit more careful when we start talking about those kinds of retirement assets. But in general, the treatment of retirement assets is much better because, as Rhonda mentioned, they count the income, but they don't count the asset value. And that's a huge benefit when you're doing eligibility planning, because so many Texans and Americans, frankly, these days are saving for retirement through these kinds of vehicles. It really helps to be able to exclude those in the right set of circumstances.
And also keeping that income for the spouse at home has a lot of value in a lot of cases for families, especially
Absolutely.
when the spouse at home needs to take care of the same bills, the house, yard, that kind of stuff. At this point, the examples I'm giving are talking about the nursing home. So I want to take just a minute to talk about the timeline of planning and application for someone who's in a nursing home. So right now it's February 25th. If I wanted to get a person eligible for Medicaid on March 1st, when we're talking about planning, the planning comes ahead of the application. And so you might think of Medicaid as a person getting a ticket and they're buying a ticket to a train, and that train only leaves on the 1st of the month. So if a person's applying for Medicaid and they want to be eligible as of March 1st, then it's really important that that person accomplish the planning, get the numbers low enough so that they meet the eligibility rules before close of business on the last day of February. So the planning happens in February. That's what secures eligibility. The application is done in March, and Medicaid takes roughly 45 days. Sometimes they do it more quickly. Sometimes it may take a little longer depending on the case and their workload. But whenever they do finish, they're going to come back and approve that case back to March 1st. So the overall timeline on a nursing home Medicaid case is from planning to approval 2 to 4 months. And again, that distinction of getting the ticket punched to the train, and that train only leaves on the 1st of the month, is really important. If I have at close of business the last day of February, if I've got too many dollars in my bank account, say I've got $2,010, I just missed that train for March. I've got to wait all the way till April. what comes after March, April. Sorry. So anyway, with the nursing home application, I'm demonstrating this timeline just so you can see it's more of a set timeline. And if I'm never in a nursing home, it is possible for me to apply for some community-based benefits for Medicaid. But the rules for that, the look-back periods, the way that penalties are treated, the way that you apply in general is very different. So I'm going to say this now, and then I'll probably come back and say it again. The fastest path for a person applying for Medicaid to accomplish two goals: to preserve their assets and get on Medicaid as quickly as possible. The nursing home path is the easiest way. By comparison, if I'm never in a nursing home and I want to apply for Medicaid and ask them to cover assisted living, the way that I would start that is by getting on a wait list. Prior to COVID, the wait list was moving 3 to 6 months. So basically I would put my name on that list. When I get to the front of the line, they're going to reach out to me and say, okay, now you can apply for Medicaid. When COVID happened, the list stopped and they just started moving it again. But I would expect now that it's moving, there's probably a lot more names on it, and maybe it's going to take longer to reach the front of the line for now. But in any case, I can't do the same kind of financial planning if I'm applying from the community for community-based services. So if I have anything going on in the past 5 years that's going to create a penalty, I'm basically going to have to wait that time out. By comparison, if I go into a nursing home first and I get approved for Medicaid for the nursing home benefits, and then my health improves where maybe I can go back to the house or to assisted living, then my Medicaid benefits can follow me. So it's really important to just realize that difference. And anytime when you're working with families where a person is in the nursing home, it might be to their advantage to get the Medicaid coverage while they're there, and then talking about going back to the community where those benefits can follow them. So again, the thing here on this slide, applying from the community, we start with that interest list. When their number comes up, then they can apply. Again, planning techniques are limited. There's different rules. So you may be in a position where that person has to wait 5 years really before they can get covered for those community-based services, unless they're in the nursing home first. So again, when you're applying for nursing home benefits or from the community, either one, Medicaid's going to look at medical needs. If you're in the nursing home first, you got to skip the wait list. You have a lot more flexible planning options in terms of preserving that person's assets to last longer for them. And I would like to take just a second, all this talk about preserving assets. A lot of times people think, oh, that's just kids wanting to preserve inheritance. When we talk about preserving assets for someone, if we've been able to set some things aside, we've got a pile of money to supplement their care. By comparison, if they go broke before they seek Medicaid, all they have is $60 a month pocket money or personal needs allowance, and there's nothing else to pull from. So when they've been able to preserve assets, the family might be able to pay extra for a private room or pay companions or sitters to kind of sit with that person, extra clothes, things for their room and things like that. Maybe also a means to have money set aside to pay house taxes and things like that, since the person's income will no longer be available for those kind of things.
Hey, Rhonda, let me hop in here real quick. I got another question that's relevant at this point. Ann asked us, if someone needs to get into a nursing home facility from home, do they have to pay the full first 30 days before they can apply? So I'll touch on it and then maybe you could follow up, Rhonda. There is a concept out there called Medicaid pending. And that is a situation where you can, if the facility accepts Medicaid pending applicants, you can get someone in the nursing home and you can have them paying their anticipated copay portion to the nursing home based on their income and the calculation of that while they're pending. So in other words, they go in and they're paying that lesser amount from day one, basically. And basically what happens is once the Medicaid application is approved, usually that takes from 30 to 45 days. Sometimes it's quicker, sometimes it's not, but that's the average. So they're there paying that lower amount during that first 30 to 45 days. And then when Medicaid gets approved, Medicaid will pick up back to the date of the application so that there's no any additional out-of-pocket expense. Now, if you miss the mark just a little bit on the estimated calculation, maybe there's a little bit there, but Medicaid pending is a way to get them in the facility and get them paying what they're ultimately going to pay when they get approved for Medicaid. If they don't take Medicaid pending, then you are unfortunately in a situation where you have to pay the nursing home private pay rate until they get qualified for Medicaid. Medicaid then retroactively pays the facility, and then that money usually comes back from the facility to the applicant or the applicant's family if they fronted the cost. So ultimately, from day one, they get covered if they're approved. It's just a matter of, do I have to pay in advance and get it back, or can I pay at the amount where I'm gonna be when Medicaid gets approved, and that's that Medicaid pending status.
And on the nursing home side of this, they're different. So whenever a person is shopping for the facility or finding that Medicaid bed they need to be in to apply, the term or the concept of Medicaid pending really depends on the facility. Often if the facility is doing the application or a person is applying on their own, facilities might be more inclined to have them private pay until it's approved. Whereas if you're working with a law firm or the facility's helping you with that pending application, then they might only require that co-payment. But in any case, when that case is approved by Medicaid, they are going to come back and pay back to that eligibility date for them. Other ways to finance long-term care, veterans benefits. This concept is huge in and of itself, so sometimes we do educational seminars on that topic as well. Briefly, let me just describe it as when you have veterans, whether they're married or single, or if you have a widow of a veteran, then they can get some monthly tax-free cash to help cover medical expenses. The short on how that works is if I'm a veteran, I served during the right war periods. I didn't have to be boots on the ground in it, just in during the right time. Say, for example, if my doctor wants me to go into assisted living, that assisted living may count as a medical expense. And if my assets are below a certain threshold, the way that they're going to look at my income is, if say my income is $1,500 Social Security, I need assisted living and that costs $3,500. The medical expense in this example of $3,500 is much more than my income. So it effectively zeroes out my income and the VA would award me the maximum benefit. The benefits that people get, there are maximums with VA, and there are different amounts based on whether I'm married, married to another veteran, married to a non-veteran, if I'm a single veteran, or if I'm the widow of a veteran. So the amounts will change, but what's really nice about it is the VA benefit for people who are eligible. Again, it's asset and income tested. That kind of stuff can be addressed through planning. But in any case, having that VA benefit might keep me home longer, might help me cover assisted living, and then eventually when I go to the nursing home, generally Medicaid may become the better option, financially speaking, to cover the full cost of care. So VA benefits are a great tool in the course of your work. If you run into families that have veterans, a lot of people don't know about this program, so you might be the one that mentions, hey, have you looked into it? Long-term care insurance.
Sorry, Rhonda, let me jump in real quick and give a shameless plug, because we're working with Marty right now on the timing, but we're hopeful to be able to offer a presentation like this for VA benefits. So hopefully in the next month or two, we can get that on the docket and provide you a lot more detailed information about how that benefit works, because it is a fantastic benefit in the right circumstances, and it is not widely understood nor even known about, as Rhonda mentioned. So stay tuned for that.
And then of course, private pay. So if we have endless amounts of resources and income to cover our household expenses and whatever level of cares we want, that's great. A lot of the times, I guess, statistically speaking, a person's life savings can get eaten up in a very short amount of time when faced with long-term care. If nursing homes are expensive as it is, if a person is trying to private pay or pay for private care at home, the costs of that around the care clock can be, much more than nursing homes. I've seen cases where it may be $20,000 a month or so. So anything that people can do to kind of make, I guess, leverage these benefits to work along with their assets, it's going to give them a lot more options in terms of care. Planning is really important, whether it's documents or the financial aspect of these things. But when people don't plan at all, they're just planning to fail. We can't keep ourselves from aging. Statistically speaking, again, out of, probably 2/3 of people need long-term care before we pass away. So it's one of those things that's so likely we should all really be aware of it. You may be faced with your own choices or caring for parents or spouses at any stage of life. So again, planning is really important in order for people to be able to make the best out of what they have for their care. You've heard me mention estate planning documents. A lot of times people hear that term estate planning and start thinking financial planning. But really we're talking about documents. And when you consider wills or trust, those things are really designed to either make some decisions for us while we're living and perhaps disabled, or after we pass away. It might say who's going to inherit from us. So kind of the basic estate planning documents are listed here. The last will and testament, think of that as a death document. When I pass away, who's going to be my executor, who's going to inherit from me. A lot of these other documents that are listed, you might refer to as disability documents. So the statutory durable power of attorney, that may commonly be referred to as a financial or business power of attorney. That's me giving authority for someone to sign my name or act on my behalf with respect to business, banking transactions, deeds, things like that. Medical power of attorney, if I can't make my own choices, I can't speak for myself, then that might name my spouse or other loved ones to make my medical choices for me when I can't. HIPAA is health information privacy. So whether it's something you do in the course of your work or maybe just when you go to your own doctor, they frequently ask, who can we release information to? It's the same thing. They can't talk to people or release records to anyone without that authorization. Directive to physicians, sometimes you hear that referred to as a living will or advance directive. That's saying, for instance, if I'm terminal or I have an irreversible condition, do I want to be kept on life support or maybe just kept comfortable but allowed to pass naturally? I want to take a second on that one. It's really common for people, especially in the long-term care world, whether they're going into hospitals or certain types of facilities, there's such a thing as a DNR, do not resuscitate. And depending on the document in your hand, it could be very different from a directive to physicians. And often people are presented with these things to sign with, I guess, under the assumption that it's more like a living will as opposed to just the DNR. So just be careful about that. The directive kind of has those circumstances attached to it. If I'm terminal or irreversible, then maybe I don't want life support. Whereas a DNR might just say, hey, don't save me. So always be careful about what you're seeing or how those things are described to you. Declaration of guardian. Say, for example, I don't have a power of attorney and I have a stroke and I can't really sign or take care of myself. When I don't have a power of attorney, my family might be faced with applying for guardianship. So if I've signed a declaration of guardian, that is me telling a court, for example, hey, if I ever need a guardian, this is who I would like it to be. And when I don't have those, anybody can approach the court and the judge might just say, okay, this person has to be the guardian and they're fit, and perhaps that person wasn't who I would have chosen. And then I'm going to ask Jeff to talk about guardianship here in just a second. But the last document is either agent for disposition of remains. That's where I can name maybe one person to make final arrangements, whether it's burial or cremation, as opposed to perhaps several family members having to sign off on it. A few more documents here that you commonly hear of or that might be used for planning. Revocable living trust is typically an estate planning tool that can be very simple or complex. And you might consider that as a replacement or something more advanced or maybe even better than a will. Trust might avoid probate, whereas wills go through probate. There are specific types of trust for retirement planning. Irrevocable trust often are used for some of these gifting type transactions or pre-planning. Special needs trusts are great. Sometimes if you have a child or family member with special needs trusts are a way to give that person money in a way that won't render them ineligible for things like Medicaid or SSI. And then a few other items, Medicaid or Veterans Asset Protection Trusts, again, often are irrevocable in nature and used in a pre-planning context for Medicaid or veterans benefits, and then Family Protection Trust. And let me stop there for just a second. And Jeff, would you take a moment just to go over guardianship process and probate?
Yeah, so the guardianship process, and we obviously do that as well. I handle most of our probate and guardianship work. The guardianship process in the state of Texas basically requires you to file an application to have someone, either the applicant or some other party, and sometimes it can be even an unrelated third party if you get a private professional guardian involved if they don't have anybody else. But it's basically a process where you get the guardian appointed so that they can make decisions on behalf of the ward, the person who needs the guardianship. It is a court supervised process. You have to be represented by an attorney when you go do it. There are two types of guardianship. There's guardianship of the person, which means that you are making physical decisions, treatment decisions, housing decisions, those kinds of things for that person. And then there's guardianship of the estate, where you're making financial decisions and providing financial assistance. Guardianship is something that we try to use only when we have no other option. In fact, the court requires you to certify that there are no lesser restrictive alternatives to guardianship, because you truly are taking away someone's rights. But if the circumstances dictate and that person is either partially or completely incapacitated, which in Texas means substantially unable to handle your affairs, either personally or financially, then a guardian may well be the only option at that point. And so if you don't have these documents in place, it can make it a lot more difficult for you to take care of someone when the need arises. And so that's why it's really important to get these documents accomplished, if you can, sooner than later, because weird things happen. We've seen people have strokes out of the blue, and now they're incapacitated, and we have to go get guardianship because they hadn't done the planning in advance. So it's really important to get this stuff done while you have capacity. And it's particularly important where you have these situations, for example, with a Parkinson's diagnosis, or ALS is even more of an example, where it's the disease process can move very quickly. You would have capacity perhaps one day, and a week or two or a month later, you may not. So it's really important to make sure that your folks know that, getting this stuff done while they have capacity is primarily important, because if they don't, they won't be able to. You can't sign a POA if you don't have the capacity to do it. So it's super important. It also, these documents also help from a probate standpoint, because ideally we like to help people avoid probate. It's not a terrible process, but it is a process. It does require court involvement in most cases. It's not inexpensive. It's not, it doesn't break the bank, but it's an expense. And you open up to the possibility of creditor claims. So if we can avoid, especially in this context, Medicaid as a creditor. Medicaid estate recovery, a common misperception is that it's a lien statute. It's not. The only way for people to assert, for Texas to assert a Medicaid estate recovery claim, is through probate. So if we can get the estate in a situation where there are no probate assets, there's nothing that we have to transfer title to that requires the involvement of a probate court, then we can avoid probate and we can avoid a MERP claim. And probate assets are those that, there are any assets that don't transfer by beneficiary designation, survivorship, transfer on death, pay on death type provisions. If it's real estate, for example, and you haven't done a ladybird deed or a TOD, a transfer on death deed, then you're going to have to probate the estate to get that real estate transferred at some level. There's different things you can do, but if you can avoid it, it's helpful to do it. So doing this planning in advance, and especially using trusts, they're a wonderful vehicle for a variety of reasons. But from my standpoint, I see them being very helpful in avoiding guardianship and avoiding probate. If you'll move Rhonda to the next slide, that would be helpful. So avoid this as well. If you can avoid these pitfalls, it'll make it a lot easier. Now, Rhonda's talked a lot about the do-it-yourself approach. It's not, maybe we should make this process or this presentation called Medicaid Made Simpler, because it's not a simple process. I mean, the fact that we've got a 40-page presentation should show that to you. But there are situations where it's not rocket science. It can be done by yourself. But by doing that, you might miss opportunities. So it's not so much you can't do it yourself, but you might miss opportunities to save money, to save time, to save headache by doing it yourself. And so that's what we mean when we say, that being a pitfall. The other thing that we see a lot is where people say to themselves, I don't really think I need to spend the money with someone to do this planning and the application and so forth. And we often see that being a penny wise, pound foolish approach, because even in a simple case, things can go wrong through the process. Health and Human Services, the folks are wonderful to deal with, but sometimes you run into problems. You run into problems where they don't understand what you're doing, they don't understand your circumstance. Maybe they're just really overworked and they're not getting to things as quickly as you hope they would. So there can be a significant emotional cost for this, because especially in a crisis planning scenario, you've got a family that is looking for, how am I going to pay the $6,000, $7,000, $8,000, $9,000, $10,000 a month that skilled nursing is going to require me to pay? That's a lot of stress. You're dealing with a loved one who's compromised mentally, physically, maybe both. You're dealing with the cost of it. You've got to live your own life. You've got a job. You've got kids. It can be a real strain, and getting someone else involved in the process so that you can offload some of that emotional investment and stress and strain many times is what people communicate to us as being a blessing to them. I'm so glad you're helping me with this, because now I don't have to worry about it as much as I have been. And the other thing about it is that from a financial cost standpoint, doing this estate planning, this eligibility planning in advance, certainly the estate planning piece in advance, makes it so much easier when you get to the point of where you need to rely on these documents than having to, scramble around to try to figure out whether you can even do them or not. So oftentimes we see it's kind of that old commercial where you had the mechanic saying you can pay me now or you can pay me later. In our experience, the pay me later option ends up being a whole lot more expensive than the pay me now option to be able to get this stuff done in advance. So you may be wondering to yourself, do I really need an elder law attorney? We would obviously suggest to you that is helpful. But why would we say that other than the selfish, obvious reasons? Elder law attorneys specialize in these things. We focus on the needs of seniors. We focus on their needs from what kind of care plan do they have in place or need to have in place, to what does that care plan look like when you effectuate it, to how are we going to pay for that care plan. And an elder law attorney can help in various stages or aspects of that journey. There are a variety of legal tools and techniques that are available to help in that process that many times attorneys who don't specialize in elder law are not familiar with or only vaguely familiar with, so that it's kind of like, a little bit of knowledge in this area. A little bit of knowledge is a good thing, but it can also be a dangerous thing because you can miss things. It is complicated, and if you're not familiar with the legal tools and techniques, you might make a mistake, but more importantly, you might not be able to take full advantage of the tools and techniques that are out there. And elder law attorneys are trained to be able to identify and spot issues and deal with those issues. So the takeaway from this, from my standpoint, is, what do you do from here? You might be listening to us drone on for the last hour or so because you are an individual who's interested in this topic, because you have a loved one or maybe yourself where you're dealing with these kinds of issues. You may be a professional in this area. And I know that there, from looking at the participants, there looks like there's a lot of you out there who, you'd like to understand how you can help your clients and get them the help they need. In other words, basically steer them in the right direction based on the information that you're getting. The reality is education, as I told you at the outset, it's important. That's why we're passionate about it. There are others out there like us that are doing this, that are educating the public, and that's a great thing. If you are in a situation where you would benefit from having additional information, we can certainly help with that. I think that's the end of our slides, Rhonda. Is that right? So.
Can I jump in for just a second?
Please.
On the slide here with contact information, there are a handful of things that we talked about today, like Medicare savings. I don't know, Marty, whether there's an attachment for that, but I do have a PDF. I'm happy to email you. So that Medicare savings program, basically for people with lower assets and low income, it's again a way to get Medicaid to cover some of those costs. So that there's one handout that has kind of the website and describes those programs and limitations, or the asset and income limits. So if you'd like something like that, feel free to reach out to us. If there's any topic covered that we didn't get into quite enough, or that you still have questions about, again, I welcome you to contact us with any of those kind of questions. Sorry about that.
Sheila did share with me the attachment, and that will go out as a link with the follow-up email when we're, and it'll be an hour or two, but after we're done, but you will get a follow-up email with that.
Okay, perfect. And at this time, does anyone, Jeff, are you still viewing the questions? We'd like to open the floor for anyone with questions.
One of the things I'd like to throw out is to make sure everybody knows we are recording this, and everyone registered will receive a link to the recording. It'll be about 3 days before that I can get that uploaded. But once I get that uploaded, you'll get a link to the recording, so you can share it, do whatever you want with it. Go ahead, Jeff. I'm sorry.
Rhonda and Jeff, there are many, many questions.
Yeah, Sheila, if you would, if you don't mind, I've got them up here, and so rather than having to have you read them and then
Sure.
us answer them, I'm happy to do that.
That's fine.
That's okay with you. So I know we've got a lot of questions. We're going to do our best to answer all of these. I've been trying to answer them as we go in the chat section. So for those of you who put those in, and I was able to answer them, that's good. There are some in here that I'm going to try to get to, but I know we're limited in time and we want to be respectful of y'all's time.
Well, choose Matthew's first, because he asked that a long time ago.
Yeah, I got you. But I just want to let you know that we're going to get to as much as we can. If there's a question that we don't get to or adequately address, feel free to email Rhonda or I offline, and we'd be happy to answer that to your satisfaction. So Matthew asks, please address the special concerns when there is a disabled adult child with special needs who's already on Medicaid and having the parents' assets put into a special needs trust. I'll take that, and Rhonda, if you have a follow-up, feel free. But this is near and dear to me because I actually have a disabled adult brother. He's Down syndrome, and my parents did exactly this kind of planning for him. They created a special needs trust for him, and they also have drafted their wills so that when they pass, his inheritance goes to his special needs trust rather than to him directly. And that's very important because having an asset inherited like that can well knock you off of Medicaid. So you either want to plan for that using the special needs trust by creating that in advance and then having a will dump into that, or another alternative is to do what we call a testamentary trust. And that is a trust that's built into a will. The important distinction is that if you create a special needs trust, that exists now and can hold assets now for the benefit of that person. If you do a testamentary trust, however, that will is only applicable upon death. So the trust doesn't exist until the person or persons die, and then that trust springs into existence and receives the assets from the parents. So yes, there is a very important need, and it's not just disability with children. If there is anyone that's provided for in your will, then you need to make sure that you're making sure that you're not disqualifying them from either existing benefits or making it more difficult to qualify for benefits in the future. So great question, Matthew. Hopefully we answered it satisfactorily. So go ahead.
Oh, sorry. Sometimes if you run into cases where perhaps the parent didn't do the type of planning that Jeff is talking about, say if you have a special needs person who is inheriting something outright, depending on the age of that person, sometimes you can do self-settled special needs trust planning. It's subject to different rules. There are also master pooled trusts. So the ARC of Texas, if you have a beneficiary who's less than 65, they may be able to contribute to a self-settled type trust through them, the master pooled trust, again, without losing their benefits. So anytime you run into a situation where someone is about to get an outright inheritance and that person, maybe the estate plan that doesn't have those fallback special needs trust provisions, it's really important to seek help. But there are some cures out there or some helpful planning tools available as well.
Okay, so Peggy asks, what's the difference between Medicare and Medicaid? I'll answer, Ron, and then you can follow up if you have something. So think of Medicare as health insurance for long-term care. So when you go in the normal scenario is you fall, you have a stroke, you go to the hospital, you're there for more than 2 midnights, you're qualified for Medicare to cover a portion of that stay, and then you discharge into a rehab facility, for example, and you're there for whatever period of time you need. Medicare is going to pick up the first 20 days of that without further cost. Days 21 through 100, Medicare will still pay, but you may have your own copay if you don't have a Medicare supplement policy. After day 100, or usually sooner in our experience, because these Medicare Advantage plans typically like to kick you off early, or supplement plans like to get you out of there earlier than the 100-day maximum. So regardless of whether it's day 22 or day 100, at some point Medicare is going to run out, and Medicaid then becomes the payer of choice for that long-term care. Anything you want to add to that, Rhonda?
No. Well, I guess yes. After a person is on Medicaid, they're going to keep Medicare. Medicare is going to continue to pay for doctors, maybe prescriptions and some of those things. And Medicaid is picking up the rest of some of those costs, whether it's the nursing home bill or things that otherwise might be out of pocket. So Medicaid pays last, Medicare pays first.
Okay, I apologize. I'm moving through these quickly. I feel like I'm kind of speed dating here, but we're trying to get as many answered as we can. Kinder asks, in considering assets, if the person is diagnosed with dementia and is a retired teacher, has a Medicare Advantage plan only, but has a death benefit of $10,000, how is that considered? Rhonda, you want to take that one?
Say that again, the death benefit?
There's a death benefit of $10,000. Let me try and then see if I do a bad job, fill me in. But the death benefit of $10,000 really doesn't have any application to countable resources. That only applies when the person passes, and then it's a moot point at that point. The difference that you may be thinking about is if you have a policy of any type, life insurance policy, retirement benefit, whatever it is, and that has a cash value, that cash value is going to count in most circumstances as a countable resource for Medicaid. Okay, so this one's definitely going to be yours, Rhonda, because I know you deal with this a lot. I had a business office manager tell me that a person must be in a nursing facility or skilled nursing facility for 30 days before they can apply for Medicaid.
There is some logic behind it, but it's not entirely true. What happens is before a case can be certified or approved, that person has to meet that 30-day requirement. So generally speaking, if you applied too early, the application might be delayed to allow that time to elapse. Quite honestly, a lot of times when the applications are done, like if you think about the timeline we mentioned earlier, Say if, again, if we're working off a March 1st eligibility, we plan in February, do the application in March, and it might be later in March. So that 30-day issue generally is not going to be a problem. But an important distinction is you may not want to apply too early because it could end up delaying that case. Or say, for example, if you applied in February before you were in the nursing home at all, you're going to get denied.
Okay. Ada asks, so Ann, I'm going to, the VA at-home aid benefit, I'm not as familiar with that. Rhonda, I'll let you chime in if you are. Her question is, she heard there was a 1-year waiting list for that benefit. And I know being a veteran, Rhonda, you may have more intel on that than I do.
There, and say again how they refer to the name of the program.
The VA at-home aid benefit. She heard there was a 1-year waiting list. Is that true?
I don't think so, but I may not be catching the correct program. There are a lot of programs through the VA. And the one we're speaking of mostly is aid and attendance, which is related to medical costs. It is important to realize sometimes that, say for veterans that serve during the right periods, it is possible, even though they are at home, to get a portion of that benefit, or if their income is low, to get it. Anytime you apply for VA, the VA turnaround time tends to be longer than Medicaid. So while there may not be necessarily a wait list on it, the application process could take 4 to 6 months or more. And typically, depending on when it was filed, you may get a back payment to that date. We do have, if you guys want to email one of us, we do have some numbers or a little information we can provide on VA that may be helpful to you as well.
And I want to add that we're working on the VA for April. We've got a different topic we're going to show you in a minute for March, but we're working on VA for April.
Excellent. Okay, next question. Durable power of attorney only applies for cognitive incapacitated patients. Is that correct? No, it's going to depend on what the power of attorney says. We draft our powers of attorney so that they're immediately effective, unless the client doesn't want that, obviously. But we like it to be immediately effective. We don't want to rely on incapacity to allow the agent to act, because incapacity is a big reason why they act, but sometimes we have need for an agent to act if they're not incapacitated. Maybe they're out of the country. Maybe they're unavailable. Maybe the Snowmageddon happened in their neighborhood and they don't have internet or phone access and they need help getting something done. There's lots of reasons why you might need an agent to act for you under a power of attorney that has nothing to do with incapacity. So we always encourage our clients to not make the POA dependent on incapacity and make it immediately effective. Let's see. If a spouse passes and has retired, okay, let me just read this here.
Rhonda, can I get you to put the last screen up? I know people are getting off from time, and we can keep going as long as you guys are willing to go. There's one more slide after this.
Oh, sorry about that.
That's all right. I'm just trying to let everybody know that we're doing next month, but you go right ahead and answer the questions. I just want people to know that before they get off.
Okay, so Marty, why don't you go ahead and talk about that, and then I'll start answering questions for whoever wants to stick around.
That sounds great. I just wanted to let you all know this is our topic for next month. We're going to do the same date, same time. My loved one just passed. What now? And so I just want to make sure you're aware of that. And you're more than welcome to stay on and ask questions, or you guys, as long as you guys are willing to answer them.
Okay, fair enough. So I had a question when I was talking about guardianship. Would this be similar to conservatorship? The answer is yes. Guardianship is what we call it in Texas. Many other states call it conservatorship, but it's basically the same thing. It's a situation where you have incapacity and you have a need to be able to take care of someone. The other thing that I'll mention here, and we probably should have mentioned this earlier, I should have, and I didn't, but that is that what we a lot of times see as well are minor children who have incapacity. So, you know, when my brother was 17, he was incapacitated, but he was a minor, so my parents could do whatever they needed to for him. When he turns 18, that's no longer the case. They are no longer presumptively able to act for him or get information for him. So we do a fair number of what we call age-out guardianships, where that individual, they're incapacitated. Once they become 18, they need someone to help them. There are different things that we can look at when we do that. Maybe it's something less than a guardianship, but it is common that when we have an incapacitated child, when they reach maturity at 18, we then have to go do what we call an age-out guardianship and get the parents appointed as the guardians so that they can help that person. Let's see. Antoinette has a question about what happens to the home once the person dies if they're on Medicaid. If I'm reading your question correctly, I think that's what you're asking. When you pass away, if your house is part of your probate estate, you're going to have to probate it, probate the will, or do an intestate heirship to transfer title of that home to whoever it's supposed to go to. The exception to that is, well, and when you do that probate, if there has been Medicaid benefits paid for that individual, you will get a notice from the Medicaid Estate Recovery Program that says they're going to try to collect those benefits that were paid. They can only do that if there is a probate. So if you have done a ladybird deed, for example, or a transfer on death deed, where the title to that house passes outside of probate just by virtue of filing a notice of death, then MERP is not going to have estate recovery. They're not going to be able to come after the house, and the house will pass free and clear of that Medicaid estate recovery claim. Can you use funds a senior has to pay for an elder care attorney to spend down money in a savings account? Excellent question. And yes, you can. That is part of an authorized, what we call spend down. It's a way to remove countable assets from the estate of the applicant so that we don't have to worry about those when we go through the eligibility process. So absolutely is a relevant expense, and an expense that is not going to be penalizable. Same things with like anything that the applicant really needs. So if they need a new bed, if they need a television, maybe some furniture, maybe a motorized wheelchair. I mean, there's all kinds of things that can be a valid spending tool to reduce the amount of countable resources in that applicant's ledger, if you will. If a parent signs a living will and durable power of attorney in 2012, is it still valid? Wonderful question. Thank you for asking that, Bobby. The answer is it depends. We always recommend people to update their documents in that circumstance where you've got a document that is old, but relatively speaking. They're not quite as bad as vegetables, but they do have a shelf life, right? So we always encourage people to revisit their documents every 3 to 5 years to avoid them becoming stale. The problem that we have, especially with powers of attorney, not so much with living wills, but especially with durable powers of attorney, is that if you take a 12-year-old durable power of attorney to a big box bank, the odds are favorable that you're going to get declined because they don't like old documents. We've even seen situations where banks are requiring fresh POAs from within 90 days. That's ridiculous, obviously, but it is out there. And remember that powers of attorney are invitations for a third party to act on behalf of the principal. It is not a directive. You cannot force a third party to accept it. There are some more protections now than there used to be on that front. But the reality is, if you don't like my power of attorney, you don't have to take it. It's an invitation. That's why powers of attorney are good. But they don't always work. And the Declaration of Guardian is a helpful document because that gives you advance say-so into who your guardian should be. If you get into a situation where someone is refusing your power of attorney, the only option you have is guardianship. You want to be able to have some say-so into that. If a spouse passes and has retired from non-Social Security paying entity, the surviving spouse is not eligible for the spouse's benefits. So this is really more of a comment than a question. So I'm going to mark that as done. If a parent signs a living will with a durable power of attorney in 2012, we just answered that one. So we're done with that.
No, Kendra there was a question attached to that.
Okay,
Read it again.
My apologies. You got it in front of you. You can go ahead and read it if you do. I'm trying
I'm
to
get it too.
Well,
Um,
Marty will have it. I don't have it.
I'm trying to find it here. You said it was from Kendra?
Yes.
I'm not seeing it either. It should be in the answered file, but it's not showing
Okay,
up.
so I've got it.
Oh, you got it.
Spouse passes a retirement, which is there a way to apply for those benefits for the surviving spouse to aid in long-term care? So here's the question, Rhonda. If a spouse passes and is retired from a non-Social Security paying entity, the surviving spouse is not eligible for those survivor benefits. That limits the income for the spouse. How does that affect Medicare and Medicaid qualification? And is there a way to apply for the benefits for the surviving spouse to aid in long-term care?
In terms of countable income for Medicaid or VA, it's going to be the income the person is receiving. So with Medicaid, it has to meet that same qualification. If they're in excess of the limit, they can do a QIT. With VA aid and attendance, what's important is if the medical expense exceeds that person's income, they can get the benefit. For VA, if the surviving spouse is not divorced, remarried, and they meet all other criteria, they can apply for the VA aid and attendance benefit. And they're going to get the maximum for the surviving spouse, not as much as the veteran, but they can still be eligible for the benefit.
Okay, I have some questions that were sent to Marty, who sent them to me.
Okay.
Okay, there's 4, and it's from the same person. What is the difference between Star Plus and Star Plus waiver? And how do you apply for those programs?
Rhonda, you want to take that one?
Yes, sir. Think of the Star Plus as the nursing home. And when the term waiver is used, that's generally for the community. So say, for example, if a person is in the nursing home, they get on Medicaid in the nursing home, and then maybe they're able to go to assisted living, that person can apply for a referral to that waiver program and have the Medicaid benefits follow them. So I've done quite a number of those for people who are on nursing home benefits first. If a person is not in the nursing home and is not on Medicaid for nursing home first, then the way that they apply for the waiver program is to get on that wait list. When they reach the front of the wait list, then Medicaid reaches out and says, you can apply for benefits. They send someone to kind of do a medical evaluation to see, does this person have the medical need for whichever community service they're applying for, such as assisted living. So in terms of the fastest path to get the waiver, which is community benefits for Medicaid, if the person happened to be in the nursing home first, that kind of kicks them to the front of the line, which is great. They also have more opportunity to do some of the preservation techniques we've mentioned. But otherwise, you start out by getting on the wait list. While we're on the subject of this, if anyone listening needs contact information, or if you would like more information about how to get on that list, please feel free to reach out, send an email, and I'll get you the number.
Okay, next. When a client has an MCO, such as Molina, Superior, etc., how did that person apply for it?
So I'll start and you can chime in, Rhonda. Typically, the MCO is assigned by service area. So if you apply in, North Texas, there are particular MCOs that will get assigned once you get approved for Medicaid. So think of the MCO in that context as basically the care manager, if you will, for those benefits, for those healthcare benefits going forward that you become eligible for when you get approved for Medicaid.
Next question. When applying for long-term services and supports on yourtexasbenefits.com, is that considered Medicaid?
Rhonda?
Anytime you apply for Medicaid, if you ever get on Your Texas Benefits, they'll ask you a few questions for the type of services you're seeking to apply for, and it'll kind of direct you to the right way to apply for it. And so, for example, if someone is looking for SNAP food benefits as opposed to Medicaid for the nursing home or healthcare, you might encounter 2 different applications. But generally speaking, whenever you're applying through that program, they may test you for multiple programs. So for example, if you do a nursing home application, they are going to test you automatically for Medicare savings. What's really important to realize is if you apply too early, say if you're trying to get on that waiver program and you apply for Medicaid before your number reaches the top, they might test you for things like Medicare savings, but you'll ultimately get a denial for perhaps health benefits or the long-term care services. But again, when you go through that program, they'll have some icons on there on your Texas benefits. So when you answer those questions, it is going to direct you to the right type of application for you.
Okay, the last question she has is, does Medicaid pay for assisted living facilities? And if so, how do you apply?
It does apply for, it can pay for assisted living, but the distinction is how you're getting to assisted living. So if you're in assisted living and never in a nursing home, you first start out on that waiver list, the wait list. Basically, you would call and provide information, name, address, phone number, social security. They'll put you on the wait list. And then when your number, when you kind of make it to the front of the line, that's when they'll reach out to you and send you the application to apply. So if you don't do the wait list first, they will deny the application for assisted living. If you are, whether it's for you or someone, a family you're working with, if what's important for people is even if they're on that wait list, if they happen to have a health event where they have a hospital stay and they're in a nursing home, at least for a temporary period, it's a great time to pounce on that nursing home application, because if you can get it approved before they're discharged from nursing, meaning they have medical necessity to be there, if you're on nursing home Medicaid first, then you can ask for the referral to assisted living and bypass that wait list. If you are on the wait list, whenever your number comes up, if the situation has changed where you don't want it, you just say, hey, I'm not going to apply. But again, that wait list is key if you're applying for assisted living without being in a nursing home first.
Okay, so I'm trying to pick up some of the questions that were in the chat that we perhaps didn't address fully. There were a couple of questions about powers of attorney. We talked some about that. The specific question was, is a medical power of attorney simpler than guardianship? Absolutely. Any power of attorney is simpler than a guardianship. How do you get one? Typically, I would encourage you to get a lawyer involved to help you draft those documents, because although we do draft one-offs, if you will, we'll draft a medical power of attorney if that's all you need. Typically what we do when we draft those documents is to do them as part of an overall plan. And the reason for that is because in our experience, if you don't have a medical power of attorney, you probably don't have a financial power of attorney, you probably don't have an advance directive, you probably don't have a declaration of guardianship. And so all of these support documents that are available, if you don't have one of them, you likely don't have any of them. And so it's important to put all of those things in place because they all play a different role in how you care for someone. If you have a power of attorney, you don't necessarily need to have a guardianship. If it's working for you, then you don't need a guardian. You only go for guardianship when you either have nothing or what you have isn't working adequately. Let's see. So the forms for advance directives and frankly for statutory and medical powers of attorney, those forms are actually in the estates code. It's a Texas statute you can find if you get online and look for it. But again, I would encourage you to not take the DIY approach. If you need an advance directive, I would encourage you to reach out to an estate planning lawyer or an elder lawyer to help you draft those, because it's not only what's in the form, it's how the form is signed. So for example, there are many forms that have to be, virtually all of them have to be notarized. There are many forms that have to be notarized and witnessed. So it's not just the language that's in it, it's how you do it that makes them effective. And that's where an estate planning or elder lawyer can be helpful on that. Let's see. Another question, can a family member apply for Medicaid reimbursement to get paid while caring for their loved one? The short answer is no, but Rhonda, you want to explain why?
Well, typically Medicaid is not going to cover, I guess a common example you run into is where a parent has already been paying a child as a caregiver. Medicaid takes the position that that's going to be a gift that creates a penalty, because they're basically assuming even like a child shouldn't be paid for mowing the yard, because that's kind of their job as a family member to help that person out. In comparison, under the VA program for aid and attendance, a family member can be paid as a caregiver when there's a caregiver agreement. But when you get to Medicaid, it's really important. It is possible for that to be a qualifying expense, or at least prevent a penalty, that it has to meet very specific criteria. So for the most part, while it works for VA, it can be a big pitfall for Medicaid, and we frequently don't want families in a position where a parent is paying a child as a caregiver.
We have another question. I think this is in regards to community-based Medicaid. How long is the wait list currently? Star Plus wait lists are terrible, but Rhonda, elaborate on that.
Yeah, before COVID, the wait list was taking about 3 months. Historically, a long time ago, that wait list used to be almost prohibitive because it took so long to get to the front of the line, the person may have passed away already. So prior to COVID, I would say the average was 3 to 6 months. They just started moving the line again in February. So to better gauge how quickly it's moving now, what I would do is, out of the people I've got on the list currently, if I call now to see where they are on the list, and then I call again in March, that's kind of going to give me an indication of how quickly they're moving. So while I don't have a good solid answer for that question now, because it remains to be seen, I would guess it's going to be 6 months to a year, possibly, for all those names to start moving and getting cleared off of the list, because it's been paused for just about a year.
Okay, if someone has SSI Medicaid and then needs long-term care nursing, is it easier for them to qualify for long-term care Medicaid? Do they still have to stay 30 days in the nursing home before qualifying?
When you're doing the nursing home, they are going to have that 30-day time period has to be met. What's important to kind of think about in this example is a person's age and whether or not they're considered to be disabled by Social Security can play into this. So say, for example, if you have someone who's not 65 yet, maybe they're just 60. If that person has some kind of health event that lands them in the nursing home, they're not by default declared disabled, which means either they need to apply for Social Security, or sometimes Medicaid can do a disability determination. So keep that in mind. If a person is already on SSI or declared disabled, the way that they apply for Medicaid may differ a little bit, but ultimately if they're in a nursing home, that 30-day requirement does need to be met. And I don't want that to be confusing, meaning kind of like the question someone asked earlier, do you have to be in there 30 days before you apply? No, not necessarily, but that case isn't going to be certified until that requirement's met.
So we have a question on aid and attendance. I have started an application for my mother for VA aid and attendance. Can I, or should I also apply for Medicaid to pay for assisted living? She has very little money and that needs to change. I'll start, you could follow up, Rhonda. If you are, I would suggest pursuing the VA application for aid and attendance if she qualifies. Understand though that that's going to be likely going to be a very long process, especially right now. You know, sometimes we can get VA applications approved in 3-4 months maybe, but it's not uncommon, even if we use their expedited process, that these applications are taking 6 or 8 months to approve. Now, the good news is when they're approved, the benefits are retroactive to the application date, or even earlier if you did a notice of intent to file. But there is that lag time there. So I would say go ahead and get the VA aid and attendance application in as soon as possible. There are resources for you for help with that. A free service that not a lot of people utilize as much as they should is a veteran service organization. There are plenty of those out there. Veteran Center of North Texas is a wonderful one here in the Dallas area. They can provide a lot of assistance with that. Obviously, as elder lawyers, we can do that as well. For Medicaid for assisted living, you're really kind of talking about this STAR Plus waiver community-based services program. So you can apply for it, but the difficulty is going to be if you're not already on an interest list, you're going to be starting at the bottom and you're going to have to percolate your way up. And that's going to take a while, as Rhonda was describing.
Frequently, if there's not enough resources to cover care during that time period, the scary part is you can run out of money before you're really eligible to apply for the services. If you're in a situation where it's possible that that person might have medical needs to be in a nursing home, that might be something to explore. When we use the term medical necessity, if you're not in nursing, you might approach a nursing home and ask them to look at the clinicals for this person to see if they meet that medical need. If they do, you can consider getting them on the nursing home Medicaid first as a means to kind of bypassing that long wait. Again, right now that wait, I imagine it's going to be longer than normal on the wait list just because of the backlog from the shutdown related to COVID.
So a related question, well, first of all, does STAR Plus Medicaid cover in-home care?
Anytime you're leaving the nursing home, you're on the waiver program. And anytime you're talking about community-based care, it's the medical need is really going to drive the bus there. So whether you're applying from the community or say you're already on nursing home Medicaid and you ask to transition to this waiver program, they're going to see what medical needs you have, and it is possible for that home care to be covered. Keep in mind the medical criteria governs the type of care we need. They're probably not going, if a person really truly needs around-the-clock care with nursing, that can be met in a nursing home. I don't see that Medicaid would pay a greater amount out for that to be supplied in the community. Like I said earlier, around-the-clock home care is a lot more expensive than a nursing home. So keep that in mind when you're considering a situation like that.
Well, and here's another related question to that. We had a person basically relate that they had clients who were in facilities. They got out of the facilities and into the community, but the family caregivers were having a hard time picking up prescriptions, et cetera, because Medicaid still showed that they were in the nursing facility. And the question was, is it the client's responsibility to notify that they're no longer in the facility, or is that the nursing facility's responsibility?
For the most part, the client is responsible for reporting changes, whether it's living, income changes, anything like that that affects eligibility. But typically, when clients don't know any better or they don't properly report the changes, usually Medicaid would catch that because the facility, they're not going to show up on the census, they're not getting billed for it. But people do slip through the cracks. And ultimately, it is the client's responsibility to report changes to Medicaid.
Well, unless Sheila, you or Marty have any other questions, I think we've answered everything that I saw.
And I may have missed it, but did you get to Kelly's question on the bottom of the chat? And you may have, and I missed it.
Yeah, she was basically just relaying her experience with STAR Plus waiver. Yeah, and it's a long, frustrating process. STAR Plus waiver is a nice benefit, and it can be very helpful, but it can be frustrating to get to. The good thing to remember, as Rhonda said earlier about STAR Plus waiver, is if you have a medical event, even while you're on the waiting list, or even before you're on the waiting list, if you have a medical event, the most direct route to Medicaid is by getting them approved while they're in a rehab facility or a nursing facility. If they're there long enough and we can get them eligible, those benefits will then follow them where they go. So that is, I hate to say it's the preferred method because nobody wants to have a health event. But from a Medicaid qualification standpoint, it is the path of least resistance, if you will, to get there. So there's a related question on Star Plus waiver. We're getting a lot of waiver questions. It's my understanding the resident has to call 211 to update them if they're not in skilled nursing. I think this is just a follow-up to your earlier comment that said this should change the Medicaid from skilled LTC to community Medicaid. So yes, I mean, most often it's the client's responsibility to report any changes, but the facility should be doing that too. But take the bull by the horns, do it yourself. There's different ways to do it. Calling 211 is a fine way to update them as to changes in status. Now, if it's a change in status of resources, then you're going to want to probably do that in writing. You're going to need to send them, if you sell the house, for example, and convert that to cash, you're going to need to report that in writing, most likely. We have a question here about how do you apply? So I said there's no more questions. Now there's a lot more questions. And I, this is wonderful for us because we love doing this, and there's still almost 100 of you out there that are listening to us drone on and on and on. So hopefully you're finding this helpful, and we appreciate you being with us today. How do you apply for the family caregiver to be paid under the Star Plus waiver program? Rhonda, do you have any specific knowledge on that? I know I don't.
No, not right off the top of my head. I don't mind looking it up. So the person asking, if you want to shoot an email, I'll look that one up for you.
Okay. Does a person in rehab have to be in the skilled nursing side of things for 30 days, or does the rehab days count?
They do count inside that facility. Anytime when we're about to apply for Medicaid for someone, I always ask the facility to kind of fill out an information sheet so we have that in writing, because it's something that you don't want to overlook or apply too early because it could cause a denial or at least a delay in the case. But a lot of facilities have dual certifications in the beds, and the particular bed they're in seems not to matter because it's designated as part of that 30-day period.
We have a question. What's a good site to educate myself on the special needs trust versus testamentary trust? And then there's a description on why they're asking this question, which is basically that there's a disability there for her brother and they need to transition, and how do we go about that? So two things that I would say. The first is that we actually on our website have some really good presentations on all aspects of estate planning, including special needs trusts. So that would be a starting point is, go to our website at Haiman+Hogue.com and you can click on, we've got webinars, presentations there that you can watch. Sheila might be able to give you more information on that since I see she's unmuted. But the other thing that I would say is that we also do free consultations at our office. And I don't want to go too far afield here, but we are available if you wanted to have a conversation. We're doing lots of Teams videos and Zoom videos. If you wanted to just schedule a time to pick our brains and ask us about your particular situation and how we might be able to help, what options might be available, and just give you that education, we would be happy to do that. So feel free to reach out.
Again, this is strictly education though. If an applicant is denied Medicaid based on income, can a law firm help with appealing that decision, or who could they resort to help with this matter?
Yeah, we could definitely help with that. We typically see those as part of the overall process. In other words, we file the application originally and, for whatever reason, we get a denial and we continue to handle that through the appeal process. But we can also help if there's already been some water gone under the bridge and there's an appeal that needs to be done because of an existing application. I will tell you, and I've had some cases like this, where the original application was filed and the income was clearly over the cap. Those are relatively easy because it's an easy fix, right? You can fix that over income situation by doing a qualifying income trust. The unfortunate part about that is if you've already gotten denied, sometimes we are not able to get involved before the appeal period runs, and that's typically 60 days if I remember correctly, Rhonda. you know, I had one where they did their application on their own 3 times and they kept getting denied, and they finally called us and said, I'm getting denied, what's going on? And I took one look at their application and I could tell they were over income. It was an easy fix, but we had to reapply after we'd fixed the problem, because if you're over income, it doesn't matter how many times you apply or what you do. If you don't fix that problem, you're going to get denied every time. But yes, we can certainly help with that. Sometimes folks will go to the facilities and work with the business office managers at the facilities, so sometimes they can be helpful. But yeah, we can always look at a situation and see if there's anything that we could do to help.
Great. Y'all, this was just incredible. You guys did a great job. It was outstanding. I want to remind everybody we are recording this, and I will send out the link. The follow-up email will go out in about an hour. The recording link won't go out for a couple of days. I've got to get that processed and uploaded. But Rhonda, Jeff, Sheila, thank you so very much. It was quite an impressive job, really. I want to invite you all to join us next month for this. And again, we're going to be looking in at the following month, April, to do the one on the veterans benefits. And then, Sheila, I had one question for you about the, and I know I asked you by email, I just want to clarify the third document you sent me with the evaluation form. The people seeking nursing CEUs, they'll know what to do with that. Is that correct?
Right. It's just a disclaimer that says that that you understand that we do this for a living, but this was strictly for education. That's what it is, just for their records. The third document, they don't need to send that back. If they want it, they don't even have to open it if they don't want it. But we're required to have sent it.
Great. So there'll be 2 documents you've got to send back if you want CEUs. I'll have Sheila's email address in there. You'll need to send back the sign-in sheet, having signed that and scanning it back in, or taking a picture of it. A picture will work, won't it, Sheila?
Absolutely.
And the other one is the evaluation form for today's presentation.
Yes.
Jeff, Rhonda, thank you so much. It was just really, really good. And Sheila, thank you so much for your help in getting this together. Thank you all for joining us, and I hope you all have a great day.